Hello, folks, and welcome to this latest in our series of webinars on various issues that are rising in the public procurement community around the world. We're very, very happy that you can join us for this webinar. It's going to be a very interesting discussion of both Kolin, which is a very important decision in the Court of Justice for the European Union, and also we're going to be discussing developments in U.S. protectionism since the dawn of the Trump administration. My name is Chris Eukins. I'm a professor in the Government Procurement Law program at George Washington University Law School. I am with Jessica Tillman, with Steve Schooner. I run this webinar series. We have a recording that's going to be available of this program today. It'll be available later today on publicprocurementinternational.com and also, importantly, on the GW Law Government Procurement Law Program YouTube page. We're going to have questions and answers today. If you have questions as we're going through the program, please feel free to use the Q&A function. That's the best way for questions to be posted, and the panelists will be responding to those. I can't respond to the questions as nimbly as I'd like to, so I've asked our panelists to feel free to respond to those questions directly, and if necessary, we'll just reserve the questions until discussions until the end. We have a collection of academics and officials and former officials here. So the normal admonition that the speaker's statements are in their personal capacity isn't really necessary, but I do want to say that the statements here by any speakers are in their personal capacity. We're going to have a webinar next week on organizational conflicts of interest. At the end of the Biden administration, a proposed rule was published on organizational conflicts of interest. This is a legal issue that really has been and had its roots in U.S. law since the 1960s, but has really taken off over the last few years in the European Union with decisions like the Fabricom decision in the Court of Justice for the European Union, and it's becoming a hot issue around the world. So we'll have a webinar on that next Wednesday. It'll be at 12 p.m. Eastern, and the information is available on our blog page. You can quickly find our blog page if you just look for Beyond the Far, but the website address is noted here at the bottom. The slides from today's presentation, I should note, are available on publicprocurementinternational.com. They were posted this morning. So we have over 500 registrants today from 70 countries. Really delighted that we could use this opportunity to reinforce the international public procurement community, which has grown so rapidly over the last few decades. We're very privileged to be able to be part of this and to pass information, share lessons learned as we go forward as really an international community in public procurement. I'm going to go through a few introductions of our panelists this morning. We're going to then talk about the Court of Justice's decision in the Kolin case. Then we're going to talk about the Trump administration tariffs, which have an impact on public procurement and have some really interesting tactical aspects to them that Jean Greer will be discussing in more detail. And then if we have time, we're going to try and finish in about an hour. If we have time, we're going to have a discussion. Just a brief note of recollection for Alan Green, our colleague who passed away last month. Alan was the author of International Government Contract Law. He's an internationally recognized lawyer. With his text, he and I built a course on foreign government contracting, and we taught that for about 10 years or so. So Alan will be very much missed, and my hope is I'm working with his family so that we can continue the book go forward with the book that Alan did so much to put together on international government contract law. I'm going to introduce Anna Lakimia, who's our co-moderator, in just a few minutes. But for now, I want to pass on to our other panelists. The group here is just extraordinarily skilled in talking about various aspects of this really, really difficult issue of protectionism between the European Union and the United States. I want to first cite Jean Hallman-Greer, who's going to be talking about U.S. perspective on these transatlantic developments. She has more than 25 years of experience in international trade as a U.S. trade negotiator, lawyer, and advisor. She served as a senior procurement negotiator for the Office of the U.S. Trade Representative for 10 years. In that role, she represented the United States in the WTO Committee on Government Procurement and the negotiation of the revised WTO Agreement on Government Procurement, which we're going to be referring to as the GPA. The GPA is the acronym for the Agreement on Government Procurement. She also helped negotiate accessions to those agreements, and she actually joined my comparative law class earlier this week to talk about that. She also negotiated other government procurement agreements, other government agreements, intergovernmental agreements that have free trade components with regards to procurement. She's published extensively in law journals and other publications. She maintains a blog on international trade issues at trade.jaghe.com, and Jaghe is spelled D-J-A-G-H-E, so jaghe.com. Currently, she's the principal trade consultant with Jaghe, and she advises and provides technical assistance to governments and other entities on international procurement and trade issues. She's the author of the International Procurement System, which my students and I refer to regularly. It's the leading text on international trade and procurement. We're also joined by Professor Albert Sanchez-Grales from the University of Bristol. He's a professor of economic law at the University of Bristol Law School in the United Kingdom. He's a member of the European Procurement Law Group. He specializes in European economic law with a main focus on competition law and public procurement, which he wrote his PhD thesis, which was published by Hart. He's currently a member of the UK's Cabinet Office on Open Contracting Advisory, on the Cabinet Office Open Contracting Advisory Group. And just note that I'm hoping to be able to pull Albert into a webinar series. We have an open contracting this summer, an international webinar series. And he's a member of the English National Health Service of the NHS Independent Patient Choice and Procurement Panel. At Bristol, he's been a professor since 2019, and before joining Bristol, he held academic positions at the University of Leicester and the University of Hull, and the law faculty of Comillas Pontifical University in Spain. We're very, very happy to have Albert, as always. Roberto Carantes joins us as well. He's from the University of Turin. He's a full professor with the law department at the University of Turin. He's working on public procurement with a focus on sustainable public procurement and on remedies on the European Union Administrative Comparative Law with a focus on judicial protection. He was a coordinator of sustainability procurement in international, European, and national systems. The Sapiens program, a very prestigious program, helping develop young scholars in public procurement issues and sustainability. He's a member of the EU Trade and Investment Policy International Training Network. He was a director for many years of the United Nations Master's Program in Public Procurement Management for Sustainable Development at the International Training Center through the International Labor Organization there in Turin. He's a vice chair of the Procurement Review Board of the European Space Agency, and together with the late Professor Steen Troima, he founded the European Procurement Law Series. Rob Anderson, also joining us. He's a part-time academic, independent consultant and trainer on matters relating to competition policy, government procurement, intellectual property, and the multilateral trading system. He previously worked on the Secretariat of the World Trade Organization and held the position of senior counsel and team leader for government procurement and competition policy. In the course of his career, he has led workshops and seminars or delivered presentations on in over 90 countries worldwide. It's just amazing history. He holds the title of honorary professor in the School of Law at the University of Nottingham in the United Kingdom. He currently serves as an external faculty member in the International Public Procurement Management Program at the University of Rome Tor Vergata in Italy, and its sister program at the University of Belgrade in Serbia. He's an editor of 3 books, and he's the author and co-author of more than 100 published articles in academic, legal, and professional journals. Kind of embarrassing that Rob is a better academic than I am. Marko Turadic is an associate professor at the Department of Administrative Law at the University of Zagreb Faculty of Law. The subject of his specific interest is primarily administrative procedure and administrative dispute, regulatory agencies, and public procurement. At the Faculty of Law, he introduced regulation of electronic communications and public procurement as elective courses, as well as a series of lifelong education courses on the same topic. He's a mentor of 2 doctoral theses in public procurement law and is a national correspondent of the European Procurement and Public-Private Partnership Law Review published by Lexion in Berlin. And I'm very, very happy that Marko can join us. He's very much part of the next generation building this international procurement community. It's an honor to have you, Marko. Thank you. Okay, so we're going to be talking about Kolin. I looked around for a good photo that would illustrate what we're talking about. We're talking about this is a beautiful picture of looking out across a construction project that was clearly built by Kolin and looking across the beautiful rolling countryside of Turkey. This is a Turkish company coming, and the case that we'll be talking about, Kolin, had to do with Kolin competing for a member state procurement, and we're going to be talking about that in more detail. We give a little bit of background, and Anna, are you ready?
Yes, I am. Can you hear me? Can you hear me okay?
I can, and I apologize. I am a Zoom moron. I didn't see you there. I'm really sorry. Let me just give you a short intro, and then you can go ahead and start. Professor
Sure.
Professor Anna Maria Lechimia read law at the University of Rome, La Sapienza, and for the Americans who really don't know anything about this stuff, that's the #1 university in the University of Rome system. She moved to England for her graduate studies. She completed an LLM in international economic law and a PhD at the School of Law at the University of Nottingham. She joined the School of Law as a lecturer in September 2006 and was ultimately named to becoming a full professor in 2019. Since 2020, she's been the director of the Public Procurement Research Group at the University of Nottingham. It's a world-leading center of research and teaching public procurement law and policy, and a very, very nice partner to our program. For instance, her colleague Luke Butler will be joining me in a few weeks to talk about European defense procurement in our class. I'm really very grateful for this ongoing cooperation. She's also a research fellow at Stellenbosch University in South Africa. So with that, Anna, you have such a wonderful record, but I'm gonna hold up the train here. So if I could, I'll just turn the substance over to you.
Perfect. Thank you so much, Chris. And before I start, I think I speak on behalf of all the panelists in thanking you for organizing this event, for arranging the slides, uploading them, sharing the material. And I think that in an era when countries are inward looking and just think about themselves, academia is important that remains and stays open. And to collaborate, to reach out. And over the years, you've been an example for all of us at doing this. So thank you very much for your ongoing constant cooperation and prodding us to participate to this webinar. So today we discuss a topical issue, the role that public procurement will play in international trade. And amidst talks of new trade barriers and the rise of new protectionism, it is important to understand where government stands as regards government procurement. What will they do with their public procurement spending? Let's remember procurement is a lucrative business, over 14% of GDP spent via public procurement. So whether this market is open or not to international and regional competition is important. Now, in a recent press release, the European Commission stated that the EU plans to review the public procurement rules to allow for the introduction of a European preference in public procurement for critical sectors and technologies. So the need to protect EU companies to both ensure security of supply and protect companies from unfair competition is a motive that emerges clearly from recent EU documents, political documents, future program statements. Even the Draghi report, as you put there on the slides, talks about the need to create some sort of preference for EU companies. And it is important to remember that this is a leitmotif that goes on for quite a while within the European Union. So there is both this need to protect certain sectors, but also to protect European companies from unfair competition from third countries. So, for example, in 2019, the Commission has issued guidance on the participation of third countries' bidders and goods in the EU procurement market. In 2020, it issues a white paper on leveling the playing field as regards foreign subsidies, and more recently has adopted the IPI instrument and the foreign subsidies regulation that we will hear Jean-Marie talking about this instrument very, very soon. And more recently, as lately, recent ECJ case law has made the headlines because has consolidated the Commission's plans and the Commission approach on the access to the EU procurement market of third country national. And so you mentioned Kolin, and indeed this is the case that we will talk about today. But as we will see, Kolin is very much grounded on EU law, on the EU directives, Article 43 of the 2015 directive, of the 2014-25 directive, which is the parallel of Article 25 of the 2014-24 directive on public contracts. Very soon, we are expecting another judgment of the ECJ on these similar issues. So a very, very interesting, very topical issues to discuss today. Now, for those of you who are not very familiar with the Kolin case, very, very briefly, and I wonder, Chris, if you could change slide, please. So very, very briefly, this is, we're talking about case 652 of 2022. This case concerns the award of public contract for constructions of railway infrastructure in Croatia. The request for a preliminary ruling was made in a proceeding between the company governed by Turkish law, Kolin, and the state commissions for supervision of public procurement procedure in Croatia. The judgment was delivered by the ECJ on the 22nd of October 2024. Now, what is very interesting about this case, and I have to be brief because time is ticking. So Kolin was one of the tender. The contract was awarded to an Australian consortium led by an Australian company. Kolin complained that that the award was illegitimate because certain requests for clarifications and documents were made after the tender was submitted. Now, and therefore, Kolin asked whether the principles of fair treatment of suppliers, non-discrimination, and the correct procedure within the EU directive were breached. The ECJ decided to rule on whether Kolin, that was a foreign national, third country national, could at all invoke the application of EU law. For those of you who don't know, EU law, of course, only applies to its member states, except in certain specific circumstances that are, in this case, highlighted in Article 43 of the directive and in Article 25 of the Public Contracts Directive. Now, interestingly, the courts decided really to answer the question as to whether the Turkish company had any legitimate claim under EU law. And they said that it wasn't necessary to examine whether the provision of EU law applied in this specific case. And in the present case, the court said in really a nutshell, the court decides that it had no jurisdiction because EU law does not apply against suppliers from third countries that the EU has not entered a procurement agreement with. The court based this judgment on Article 43 of the directive, which is a parallel to Article 45. And I wrote a very brief commentary on Article 25 of the Public Contracts Directive, published in the edited collection by Professor Caranta and Professor Sanchez. In this commentary, I say that Article 25 really acts as a gateway to the European Union procurement market because it guarantees the right to enter the EU market and to benefit from the principle of equal treatment, non-discrimination, transparency, but it guarantees such rights only to certain suppliers. And this is what is very important. Who are these suppliers? Only those suppliers and goods, only those from countries who have entered an agreement with the EU. So really, Article 25 and the parallel Article 43 are there to allure other countries to enter into agreement with the EU. And it is a sort of muscle of the 27, an expression of the coherence, the internal and the external power of the EU institution. So these articles are there to guarantee the rights of operators and goods services from countries the EU has entered an agreement with, but at the same time, they preclude countries, they preclude suppliers from countries the EU had not entered an agreement with from benefiting from the principles within the directive. And here I think that this is also what is interesting, is that access is not outright precluded. And I think this is what our panelists will discuss later on. Access is not outright precluded. Contracting authorities will be able to decide, but these suppliers will not be able to benefit from EU law, to invoke EU law. And this is really where is, this is the difference between suppliers from countries that have entered an agreement with the EU and those that have not. And I think with this, I've summarized as best as I could and as quickly as I could the case. Now I shall hand it over to Jean-Marie for some reflection, a further reflection on the case.
We could just a quick second, Anna, if you could just, we talked a little about, and Jean's going to be talking about this in more detail, but could you talk about how things are supposed to proceed practically from here? Now that the court has said that vendors outside the European Union, outside, don't have those rights, how are procuring entities or contracting agencies supposed to handle this?
I think that this is going to be the problem for contracting authorities, because there is some confusion as to who has access and who has not a right to access. The point is that it will be up to contracting authorities to decide. Yeah, it will be up to contracting the authorities to decide, but they have to be very careful, because they have to grant the right to those operators that come from countries the EU has got an agreement with. So very clear guidance will have to be issued by the European Commission to make sure that no one is excluded. At the same time, it will be, I guess, a matter of national law to decide for access. And this only insofar as the EU, of course, doesn't enter any new agreement on procurement, because the moment that the EU enters an agreement on procurement with a third state, then that agreement will prevail and EU law will preempt the field from national authorities. So there will be, I think, a bit of uncertainty for the future for contracting authorities as to what position they have to take. My feeling is that it will be very much an issue of the market, the best supplier, who will be the best supplier in the market, whether contracting authority will still want to accept third country suppliers into their own market. But the key is that there is no right in terms of EU obligations, which is what really makes EU procurement law so strong.
Thank you very much, Anna. Jean?
Thank you, Chris. I think it's useful, starting in discussing the Kolin case, to understand how the EU approaches government procurement in trade agreements. It has a vast public procurement market, and it has entered a number of agreements: the WTO Government Procurement Agreement, the GPA, and numerous free trade agreements. And like all parties to these agreements, the EU specifies precisely what procurement's covering under the agreements. But in doing so, it often, on the basis of reciprocity, withholds the right for a party to participate in certain procurement unless the party provides reciprocal access for the EU in its own procurement. For example, the US does not cover transportation services under its GPA commitments, so the EU withholds the right for the US suppliers to participate in such procurement in the EU. But notwithstanding these legal restrictions, and I think this is the important point in terms of the Kolin case, is that the EU generally provides de facto access to all of its procurement, whether a country or has entered into an agreement with it or is providing reciprocal access. So the Kolin case comes in to the situation saying, okay, the EU has up to now basically allowed anyone to participate. A few member states have some more restrictive laws that just follow the GPA and FTAs. But now that you have with the Kolin case, the procuring entities now have to deny countries that have not entered an agreement with the EU or have in procurement that may be under the agreement, but they don't have rights to. It cannot demand or cannot provide equal treatment to those suppliers. And I think as Anna has mentioned, it's going to be an interesting discussion to see how they actually end up implementing this provision. And this Kolin case fits into sort of a trend in the EU, because the EU has been reconsidering in recent years its open procurement market and trying to find ways to get other countries to provide reciprocal access to it. And in 2022, it implemented what Anna referred to as the IPI, the International Procurement Instrument, which is designed to encourage reciprocity. It basically authorizes the Commission to investigate the procurement in another country if that country thinks it's discriminating against EU suppliers. And after an investigation, the Commission can either ban the country's suppliers or it could restrict its participation in EU procurement. The EU has taken its first case under this IPI, and it was against China's procurement of medical devices. And in January, the Commission issued a discriminating against suppliers, even though China is not into the PA any other agreement. And the Commission is now looking at what kind of remedies it should pursue. Earlier, I posted a blog posting on this case, and I'll put that in the Q&A section. So while the IPI could be an important tool for the EU, it has some limitations because it has to be based upon investigation targeted at a particular country and probably at particular segments of its procurement. In contrast, the Kolin case applies to all procurement undertaken by the EU. Another trade tool that the EU has also recently adopted is the Foreign Subsidies Regulation, which is aimed at precluding tenders from suppliers that have received foreign subsidies. And under that regulation, it's initiated 3 cases or examining 3 procurement in 3 different procurements. And in each case, it was a Chinese company that was participating, and they withdrew, so they haven't had to go to the point of actually taking action. So I'll stop here and turn it over to the academics to discuss the impacts of Kolin.
Thanks very much, Shane. Albert?
Thank you very much. I think I might be the only one here that doesn't really like Kolin. So I'll just try to make it short and punchy and then go away. For anyone interested in the detail, my full thoughts are here in the chat. So I think first, to me, it was not a given at all that the Court of Justice should have, or even that could have, answered the question it was not given. This was a case where a contracting authority chooses a bidder, then the decision is appealed on the basis that they had not done their due diligence, decision is quashed, contracting authority goes back to the preferred bidder and says, can I please have the documents? And the question is, can you do it at that late stage? So it was very much a case about good administration. And when the question is put to the Court of Justice, they say, oh, let's forget about that, which, by the way, is really important in trying to determine we do procurement properly, we do our due diligence. We have a long saga of cases about clarifications, documentation, and so on. But let's that set aside and look at the fact that the disgruntled bidder is Turkish. And then we go out of the way to provide a clarification without looking at the broader system. So both Ana Maria and Jean have mentioned that this was under the Utilities Directive. And one of the things that is important to say is that the Utilities Directive itself has mechanisms to disadvantage goods coming from jurisdictions that are not reciprocal, where if more than 50% of the goods in the contract come from third country jurisdictions, you can correct, for example, for price, or you can create a disadvantage in the tendering. So there's already a mechanism to correct for the tolerated third country access, but the Court of Justice doesn't look at it. The Court of Justice doesn't think about the logic of the IPI or the foreign subsidies regulations. If it was true that the EU procurement directives work exactly like the Trade Agreements Act that I think Chris has put in the chat, then we wouldn't need Kolin. It would be obvious that unless you have access, you're out. But that's not been the European approach. It's not only that de facto we've allowed for access, but what the directive has said is if you come from a third country that has an agreement, we need to treat you like we treat domestic producers. But it has never said explicitly nobody else has access or everybody else has to be discriminated against. So there's different ways in which you can understand it. So I think it was a decontextualized grabbing for a question. I have lots, I'm very cynical, but I have lots of questions about how that was raised. Who whispered into the Advocate General's ear to say, you actually need to answer this thing? Was it the European Commission? Was it a third country? We don't know because it's not a transparent process. But let's leave that aside. I think that, to me, the big problem with Kolin is that it just doesn't do what it should have done, right? If you take it as read, that unless you have guaranteed access to the European market through the GPA or a bilateral agreement, then you don't have access, then that's what the Court of Justice should have said, right? So the only reading of the directive is to say no access for anyone that doesn't have an international right to access, because otherwise the logic just doesn't hold. What the Court of Justice comes to say is that if you extend the no less favorable access to third countries, then you are diminishing the economic benefit that the GPA members and the bilateral members obtain from their agreements. But the logic only holds if then you also don't allow for de facto participation. Because otherwise you could claim, simply by tolerating Brazilian, Chinese, and anybody else to come forward, we are diminishing the practical benefit that American and Canadian and other companies derive from participating in the GPA. Which then takes us to the logic of the GPA itself. The GPA also doesn't mandate its members to discriminate against non-GPA members. So the GPA is about mutual concessions, but there's no hard protection clause that says, European Union, for you to comply with your commitments, it's not only that you give access to those that benefit from the commitments, but you need to reject access from anybody else. I don't think the GPA, and I would be interested in Rob's thoughts, would have been go if that was a requirement, because there would be lots of countries that have close trade agreements with parties that were not ready and have not yet entered the GPA. So I think that the whole logic of the trade dimension is ignored. And the other thing that is ignored is that procurement rules do many things. We have lots of conversations, but they are an instrument of good administration. And by the Court of Justice saying, well, each contracting authority can come up with its own way of how they're going to discriminate a little bit against the other ones, and people will not have access to remedies to check that, it's creating potentially a black hole of accountability and a black hole for the enforcement of the procurement rules. And it's going to create lots of problems that I think Marco is probably going to reflect on. So these are my 5 cents. This is a bad judgment that they didn't need to issue. I really wonder what the final, the origin, that whisper was. I will probably die without knowing, but it bugs me at night. Thank you.
Thank you, Albert. Thank you very much.
So, so we go back to the fold of those that are not so much against Kolin. Well, my point is that you can't judge the present international situation by the standards that we have used in the past 30 years, since 1995 and a few months before. At that time, the whole world was moving toward opening markets. It was really a moment with the fall of communism when there was just one ideology. There was this philosopher Fukushima, he wrote a book, The End of History. There is only one ideology, capitalism, liberalism. There is never going to be a conflict anymore. Well, I guess he was wrong badly. There is conflict, and this conflict has shown that supply chains are fragile. But it's not just about conflict. No one is fully subscribing to a neoliberalist approach. The People's Republic of China is not. It is more on the lines of a Colbertist model, pushing and helping its companies on the world stage. So, well, there were, let's say, hopes, high hopes, for those being young in those ages, myself. It was really beautiful. Peace in Europe, Europe united, and so on and so forth. But okay, the world is a different place. And so there are a number of instruments. Jean has already mentioned them. I would just disagree on one aspect here with Albert. The court is referring to the international procurement instrument, and in more than just one point. The EU is basically trying to protect its market. Not just its market, its economy. The Net Zero Industry Act is really about shoring the supply chain and possibly reshoring production using public procurement as one possible tool. So I wouldn't see Kolin in isolation, in a narrow history of how was public procurement in Europe in the past 30 years. I would to point at the wider picture. I would like to point at a changing, fastly changing. And I'm not saying, oh, it's good that it's changing. I'm just saying that, well, we needed to adapt to changing conditions. Dinosaurs didn't, and they basically went extinct, but birds, of course, they were managing to adapt. And of course, this is going to be shown in the revision of the directives. I really hope that the real issues Marco will be referring to on how you bloody apply this judgment will be solved, if not in the forthcoming case Qingdao, by the new directive. But most probably the new directive will also include a European preference. Why including a European preference? Because the whole ideology has changed. I'm not particularly happy about the present conditions of the world. Getting older, I tend to think that when I was young, it was much better. But concerning, let's say, world politics, well, after 1989 was much better than it is now. Thank you a lot.
Thank you very much, Roberto. And with that, we'll turn it over to Marco. Oops, sorry, Marco. I should really have a research assistant doing this stuff because I'm clearly incompetent. Go ahead, Marco.
Hi, everyone. I'm going to raise a couple of practical issues, so bear with me. So the court states that in the Kolin judgment, of course, that national authorities cannot interpret the national provisions transposing the Utilities Directive as also applying to economic operators of third countries, but this also has to apply to the General Directive and the Remedies Directive. Furthermore, if admitted into a public procurement procedure, the court states that third country economic operators can be treated, not must, can be treated with at least transparency and proportionality in mind, which can be read as allowing the possibility of ignoring those principles. But the principles of transparency and proportionality must be mandatory, as their absence would definitely violate national constitutions of the member states and Article 6 of the European Convention on Human Rights. It seems to me that this part of the Kolin judgment creates an obligation to establish a system of parallel appeal grounds for third-party economic operators allowed to participate in a public procurement procedure. Paragraphs 65 and 66 of the judgment read together do not allow the application of the majority of articles of National Public Procurement Acts to third country economic operators, and especially do not allow third country economic operators to claim a breach of an article of a National Procurement Act that represents a transposition of any of the EU directives on public procurement, including, I believe, the Remedies Directive. But what does all of this mean in practice? I'll give you a Croatian example. So the majority of articles of the Croatian Public Procurement Act represent a direct transposition of EU public procurement directives, like the definition of economic operators, technical specifications, selection criteria, and so on. But some of the articles are, and I emphasize probably, national in origin. For example, the articles establishing the appeal procedure as an administrative procedure. Are the contracting authorities now expected to know exactly what is the basis for each article of the Croatian Public Procurement Act? But even though the articles establishing the appeal procedure as an administrative procedure are probably national, it can be argued that they are also transposing the Remedies Directive. So how will we make the separation here? So can they be applied to third country economic operators or not? If we decide they can, and I believe we should, third country economic operators should be able to submit appeals to our appeal body. But on what appeal grounds? This is the main question. Most of the relevant articles of the Croatian Public Procurement Act are transpositions of EU public procurement directives. So therefore, economic operators from third countries cannot use their violation as grounds for appeal. If they are permitted to appeal, if they are permitted to participate, they can appeal solely on grounds of certain principles, as indicated by the Kolin judgment. Not clearly enough, I must emphasize. But does this also mean that breaching these principles is also a breach of EU law? Because a lot of these principles have their origin in EU treaties and EU law. So the issue of remedies is notably complex, and it must be the responsibility definitely of member states to establish new remedy rules applicable to third country economic operators. However, in doing so, member states must be really careful and be cautious of the Kolin judgment. We have a recent development also. Our competent Ministry of Economy, for competent ministry for the public procurement system in Croatia, issued an opinion on the Kolin case in January this year, stating that they will do nothing and they will wait for the Commission to do something. And the Commission stated in a roundtable in Zagreb a week ago that they are going to wait for the judgment in the Kindau case. So we're going to have a lot of waiting till we get some guidelines that the contracting authorities are surely missing. And what I need to emphasize also, that in the four months since the Kolin judgment, this seems like ancient history now, there have been no public procurement procedures, at least in Croatia, where third country economic operators were excluded in the tender documentations in the tender documentation as it should be. There have been certain informal suggestions to third country economic operators that they shouldn't participate, but nobody has dared to put the words in the tender documentation. So additionally, the rules for participation and remedies are being left to the appeal body and courts to establish, which is not a good situation to be in. So this highlights one of the more problematic aspects of the judgment. And I think this is something we need to talk about a bit more. The conflict of legitimate interests of the concerned parties. What do I mean when I mention this conflict of interest? Well, first of all, we have the contracting authorities, and they have a legitimate interest in attracting more tenders and securing lower prices. Thus, excluding third country economic operators is not in their favor, and this is something we have been seeing in the past 4 months. The EU has a legitimate interest in signing reciprocal free trade agreements and establishing a level playing field in the public procurement common market, of course. But also, EU-based economic operators have a legitimate interest in ensuring fair competition within the EU and in third countries. So this indicates that Kolin had a minimal impact. So third country economic operators still participate, and they are dealing with a lot of legal uncertainty. So, and I will conclude with this. Contracting authorities have 2 options. They can either prioritize legal certainty by excluding third country economic operators, resulting in less competition, or they can prioritize increased competition, accepting the trade-off of greater legal uncertainty. As we have seen thus far, contracting authorities have opted for the latter approach. Thank you.
Very much, Marco. With that, I'll turn it over to Rob.
So first of all, warm thanks to you, Chris, and to Anna for organizing this super interesting and timely forum. So I will begin by saying that taking due note of the significant points that have been made by Albert and Marco and others, I still have a more favorable view of the Kolin decision than some. I mean, basically, it seems to me that it says that if suppliers from countries outside the EU are to have assured access to EU public procurement markets, then they'll have to either join the GPA or negotiate some other appropriate arrangement for market access. And I think that's a reasonable position. And I think that over time, the decision will have the effect of encouraging other countries to join the GPA. That's a good thing. I take the point that there are some issues that will need to be clarified. I think that will happen over time. Now, turning to the situation in the US, which will be, I guess, the main focus for the rest of our webinar, we need to begin by noting the White House memorandum on its America First trade policy, which was issued on January 20th, the first day of the new administration. And this calls for a review of the impact of all US trade agreements. And notably, it singles out the WTO agreement on government procurement. And the review is to ensure that such agreements are being implemented in a manner that favors US domestic workers and manufacturers and so forth. This to me is a clear signal that the time has come for a robust defense of the GPA's role as a multi-purpose trade agreement, supporting market access, but also, and crucially, fostering good governance and encouraging market-oriented reforms globally. And just to be a little bit more specific about that, let's please recall that currently, several major transition economies from Central Asia and Latin America and elsewhere in the world have started the process of acceding to the GPA. And if that objective can be pursued and can be achieved subject to the appropriate market access terms, this will be a major benefit to international suppliers based in the US, based in the EU, Canada, etc., all the major existing GPA parties. So my point is there's a lot to be gained. The GPA has an importance that transcends its current impact in terms of balance of payments and things like this. Okay, now turning to the bigger picture, sure, we have to acknowledge, and I think you will develop the point in the coming slides, the current threats regarding the use of tariffs do pose risks for the stability and viability of the multilateral trading system. Now, of course, the risk here is not limited to public procurement markets. Rather, it extends to trade in goods much more broadly. And just in passing, I will note, I think that the main legal challenges to the tariffs, to the extent that they come, will not be under the GPA. There's a clause in the GPA, Article 4.7, which excludes customs duties from the application of the agreement's non-discrimination provisions. That's because the GPA is fundamentally intended to deal with public procurement policy per se. Also, as a bit of context, I need to note that the entire WTO dispute settlement system is currently in a weakened state. And this is something which has developed over time. It is definitely not just the result of recent actions under the new administration. Rather, for many years now, under Republican and Democratic presidents, the US has refused to fill vacant positions in the WTO's appellate body, sort of appeal court. This has created something known as the possibility of appealing disputes into the void. That means you appeal to the dispute to the appellate body, but the appellate body no longer exists in a functioning way, and so this makes it very difficult to pursue ultimate resolution of disputes. So that's another concern. So there's, to sum up, there's a lot going on here. Again, my view is that Kolin is basically a reasonable and even helpful development over the long term, though recognizing that different issues will need to be clarified over time. And more broadly, the time has come for a robust defense of both the GPA and the multilateral trading system. This is going to involve a mix of negotiations, because all signals are that the US administration wants negotiations and will be making demands, for example, concerning reciprocity in agreements, and other countries will have to respond to that. But we also need to bear in mind the cost of protectionism in the public procurement and other sectors. And I would just like to underline that the costs of protectionism in the public procurement sector, and this is a point that I've been developing with you, Chris, are not limited to missing out on the traditional gains from trade that academics write about. Rather, we should be noting that protectionism in the public procurement sector is really harmful, carries major risks in terms of fostering corruption, fostering supplier collusion in public procurement markets. When you close markets, nothing facilitates corruption and collusion like a internationally closed market. And the GPA is now kind of providing, serving other roles than it was originally envisioned to serve. For example, an important dialogue is going on fostering the use of green public procurement as a tool to deal with environmental challenges. The GPA now serves as a forum for sharing of perspectives amongst the participating countries. And so it has this important role of reinforcing good public procurement practices and market opening, which again transcends its kind of original role as a market access tool. Thanks.
Very much, Rob. So just take a moment for the audience outside the United States, because I think sometimes it's difficult to see what's going on in the United States. The United States is going through a very, very divisive period. There's tremendous political upheaval going on now in Washington and through the United States. And what Rob has done is he's reinforced norms on free trade, and that's going to be very much a part of what you see in the American dialogue, the political dialogue over the coming years. It's a stressing of norms that are considered important, because only by reaffirming the norms can we solve the more tactical questions on a day-to-day basis. So thank you, Robin. So we're going to have to go overtime a little bit, but if I don't talk about the Trump tariffs, I'm going to get killed at the next Bar Association meeting. So for the Americans, I have to walk through this stuff, because otherwise I have a lot of angry folks in the contracts field, and want to talk a little bit about how the mechanics of that, because they're very important. And just so for the non-Americans, just so you think I'm not doing, this is actually Trump's official portrait. Just so you know, this is his official portrait. I didn't find this like on a website somewhere. This is his official presidential portrait. There are three types of tariffs that he's put out. And one is reciprocal tariffs, and I'll talk about those in more details, which to address what are viewed as unfair trade practices in other countries. Then there are country-specific tariffs. So we're supposed to be 25% tariffs imposed against Canada and Mexico in the beginning of February, and then the Trump administration deferred those for 30 days. There were 10% tariffs imposed against China in that same slew over that weekend at the beginning of February. And then there have been product-specific tariffs imposed on steel, aluminum. The steel and aluminum tariffs are important because they're going to have an impact at the bottom of the supply chain. And an open question is how that will affect federal procurement, which is typically done at the top of the supply chain with highly finished manufactured items. So as Rob alluded to, and as Gene will discuss in more detail, there's a report due on April 1st, and that was announced by the president in the first few hours of office. He called for this report on trade agreements and foreign subsidies. And it's important, and Gene's going to emphasize, the foreign subsidies, the reference to foreign subsidies in that direction echoes almost exactly the foreign subsidies regulation. It's as though the Americans read the foreign subsidies regulation, and now they're trying to determine whether or not they should apply it reciprocally against Europe. And Gene will talk about that in more detail. That's the blue part of the slide. The red part of the slide is what came out in just the last few days in February. And these are criteria that are to be applied by the U.S. trade agencies in assessing the other nations for possible reciprocal tariffs. So basically deciding which nations should be targeted by the United States, and looking to see whether or not those other nations are imposing higher tariffs, whether they have unfair tax schemes that raise barriers to U.S. businesses, whether or not there are other perceived unfair barriers like regulatory requirements. The fourth is whether or not their exchange rates have been, in the United States perspective, manipulated in a way that hurts Americans, and the others, any other practices that the trade leaders find offensive or troublesome. So that's a February direction from President Trump to undertake this study. That's what the red is about. What's kind of amazing is that our colleague, Simon Evanet, in November, several months ago, he anticipated the February directive. Simon Evanet is an extraordinary international trade economist, and his global trade alert published this report in November, anticipating what the Trump administration was going to do in February. And importantly, by anticipating it, he also was able to anticipate which nations would be the focus of attention. He created a red flag system. And it's hard to read, but this chart next to Simon's picture on the top identifies South Korea as the top of the pyramid, the most likely to be the subject of attention by the Trump administration. And he used the 5 red flags. So you see how those red flags, I've just reproduced this portion of his report, where if there's a trade surplus between the United States and South Korea, and South Korea enjoys substantial trade surplus, whether or not there are exchange rate issues, whether or not there's U.S. exports at risk, whether or not there's been a focus on the U.S. trade representative in past reports on this nation, and whether or not there's a perception of excess tariffs, so that the South Koreans have tariffs higher than the United States. And using that, Simon and his team came up with 5 red flags for South Korea. So anticipating that means that even though the February direction from the president didn't say which nations should be targets, Simon has essentially predicted which nations may well be targets. A very interesting academic exercise, very interesting use of an academic analysis to try to foresee where policy may go. Now, I just want to go through the mechanics, which are important both from a policy standpoint and a political standpoint. So the first thing, which is surprising to all U.S. procurement lawyers, because we've never had to really deal with high tariffs, is, oh my gosh, there's an exception from tariffs for U.S. procurement. When the U.S. government is buying goods, those goods are presumptively tariff-free. Okay, that is, and we in an article we published a few days ago in the Government Contractor. There's an image of it there on the right, and it's available in Public Procurement International. In that article, we talked about the mechanics of how to handle this under the Federal Acquisition Regulation and the Defense Federal Acquisition Regulation Supplement. Just as a flag for everyone, the procedures, the processes are more complete under the Defense Federal Acquisition Regulation Supplement. They're better enunciated in the defense regulations. And that can be important as you're trying to navigate this exception. It means, in essence, that contractors that are shipping goods that might be bought by the U.S. government have to give notice to the U.S. government, and then the contracting officer and the Customs Service are supposed to cooperate in ensuring that the tariffs aren't imposed. There can be a claim for compensation if tariffs are imposed. And it's possible if, for example, there's a delay caused lower in the supply chain, if higher tariffs, for example, slow the delivery of steel and therefore slow the delivery of manufactured items, there may be delay or disruptions claims as well. So this is opening up, and first of all, it's creating a need for contractors to focus on the exception, but it's also opening up the possibility of a lot of collateral litigation because of the additional costs that are caused by the tariffs. Interestingly, yesterday, the Deputy Assistant Attorney General in the Justice Department, who handles the False Claims Unit, he gave a speech to the Federal Circuit Bar Association, and he said that there will be enhanced enforcement through the U.S. government on False Claims Act issues involving tariffs, which means that makes it even more important that contractors take preparatory steps, that they flag for contracting officials that they should be exempt. What's left open are issues, for example, of how state and local governments, how tribal governments should be handling this, because it creates substantial additional costs for them, and they are not exempted. The exemption probably comes from the Reciprocal Defense Procurement Agreement that the United States has entered into over the last decades. Those Reciprocal Defense Procurement Agreements call for an exemption from tariffs. They say that goods coming in should be tariff-free. Now, this whole scenario opens up, and I want to flag for our audience abroad, it opens up some very dangerous terrain here. What it means is that if Swedish defense material is being imported into the United States, even if the United States has imposed tariffs against the European Union, those Swedish war material coming into the United States will be tariff-free. Reciprocally, though, it's possible that the EU or the member states might just ignore the Reciprocal Defense Procurement Agreements. So, for example, the EU is not a member of the Reciprocal Defense Procurement Agreements. It's possible, and how it will unfold is very difficult to predict, but it's possible that American war material going to Sweden might face tariffs. So asymmetrical tariffs involving defense material, a political hot button. Let me guarantee you, that is a political hot button that we need to be aware of and anticipate and think around. Okay, so the other materials that might be available, that are available, other materials are available, again, on Public Procurement International, more background, including detailed background on how and how the exemption might be exercised. With that, we're going to close. And again, I'm sorry we're going a little over time, but want to close with some observations from Sheen Gira, looking forward on U.S. trade policy involving procurement. And Sheen?
Okay, I will try to be brief since time is running. But let me just sort of address the U.S. government procurement policy and the prospects in the coming days or weeks. You know, if we look at the last 8 years during both the Trump 1 and Biden, there was extensive measures to protect U.S. procurement, tightening of domestic content requirements, price preferences, mandates in infrastructure laws, and there was many things taken to protect the U.S. procurement market for domestic suppliers. It seems now that that's maybe has kind of run its course, and there may not be a lot more room for tightening the U.S. procurement rules. But I think instead, and picking up from both Rob and Chris's comment, you know, what we're looking now at and seeing is reciprocity. That's the keynote to the Trump trade policy, and I think we'll see it and we'll sort of see it in the procurement context. Well, first, they had the tariffs, as Chris mentioned. You know, they're looking for reciprocal tariffs in which they want U.S. tariffs raised to match whatever the foreign countries' tariffs are. And secondly, they're looking at reciprocal trade agreements or negotiating agreements based on reciprocity. And that's a position that the incoming U.S. trade representative has indicated he wants to pursue, which is reciprocal agreements. And so what would that mean in the procurement context? If you look at what happened during Trump 1, when they negotiated basically one trade agreement, which was the revision of the NAFTA, the North American Free Trade Agreement. And in that context, the administration tried to apply what was called a dollar for dollar policy, in which they basically told Mexico and Canada, the other two parties to the NAFTA, that the U.S. would open U.S. procurement to them at the dollar level of the procurement that those two countries covered. Now, obviously, the U.S. has a vastly larger procurement market than either country. And so Canada said no. And they said if that's the condition for joining or covering procurement under the renegotiated NAFTA, they were not going to participate. So they pulled out of any procurement commitments in the new agreement. Mexico just rolled over its NAFTA obligations with no new market access. And so that issue just kind of went away. But I would expect that if there's any renegotiation of the GPA, which could come out of this study that Rob mentioned, the U.S. could be looking at a reciprocal, you know, dollar for dollar kind of match with its trading partners. I think the bigger concern, and I think this was alluded to, is that the U.S. pull out of the GPA. It came very close during the Trump 1 administration at the very end of this term to saying, okay, we're not going to be a party to the GPA. And the question is really whether the Trump administration would care if U.S. companies lost access to foreign procurement markets. And obviously, if large companies are affected, that may change their calculation. But what would happen to U.S. companies if the U.S. pulled out? First, as was the case in the EU until the Kolin decision, the U.S. can often participate in a lot of procurement in other countries that are parties to the GPA or even other agreements, because those countries, once they open their procurement, they don't put any restrictions in place, and they let anyone participate. And Canada, for instance, has been doing the same, has been doing that, although they're now considering their own reciprocity provisions, which could mirror those the U.S. has put in place. So what you could see is that, you know, the U.S. could continue to participate in many countries' procurement, but the EU now has the two tools, both the Kolin decision and the IPI, which could be used against the U.S. So I think for the moment I'll stop here and see if we have questions.
Sure, on time, Gene, just have a quick question. How would reciprocity work since the U.S. procurement market is so large compared to, to other procurement markets? If we have dollar for dollar reciprocity, how mechanically would that work?
That's a very good question, and that was one that was discussed when the potential withdrawal was an issue. No one knows, because if you have, if you're looking at a foreign market that's a quarter of the U.S. market, do you let them participate until the U.S. has procured that amount for the year? I think it would be probably really impossible to administer. So I don't know. I wouldn't begin to guess how they might do it, but it would be very difficult. And then if you had other countries with different levels of, procurement, and so they would cut off at 100 million, somebody else at 2 billion. I wouldn't want to be a federal procurement official.
So that the audience
But I'm not
understands.
sure the Trump administration had thought. What? I doubt the Trump administration had thought about that when they were considering the withdrawal.
Well, so the audience understands. So Jean was negotiating trade agreements involving procurement for a decade on behalf of the U.S. government, and she's doing it with the stated goal of reciprocity. But as she's explaining now, reciprocity traditionally was tempered by comedy. Thanks very much. Thanks to the audience. Have a great day. Take care. Bye-bye.
Okay, thanks.
Thank you. Bye bye.
See you all soon, I hope.